Guardians ad litem and custody evaluators in Utah, what they are and what their limits are. If you're in a Utah child custody fight, you'll hear about guardians ad litem, or GALs, and about custody evaluators. They can influence outcomes, but they aren't kings whose word is law, and they aren't above the rules of evidence or civil procedure, at least in principle. Here's a candid viewpoint from an experienced divorce and family lawyer. A GAL is a lawyer ostensibly appointed to represent the child in a child custody dispute. A custody evaluator is an expert witness appointed by the court who conducts an investigation and offers recommendations for custody and parent time. In theory, GALs advocate based on the case record. Evaluators apply reliable methods and disclose their work and recommendations. In practice, both roles can drift beyond these guardrails. Common problems: GALs acting like witnesses. They're not allowed to, but they do it all the time. Summarizing what a child said in open court without the child testifying or being subject to cross-examination. That's hearsay. You can and should object to that. Evaluators without rigor. Recommendations built on unrecorded interviews, subjective notes, and thin methodology. If it wouldn't pass Rule 702 and 705 scrutiny in any other context, it shouldn't pass here. Judicial deference. Recommendations are not binding, but courts sometimes treat them like gospel. Pushback respectfully with the law and the record. 4 myths to stop believing. 1. Child testimony harms kids. There's no universal rule. Judges can take in-camera, on-the-record interviews when appropriate. 2. GALs speak for the child. No, the child has his own voice. A GAL doesn't and legally can't substitute for the child's own testimony. 3. You need the GAL's permission for the child to testify. No, you don't. 4. The evaluator interviews can't be recorded. They can, and they should be, to preserve accuracy and ensure evaluator competency. What to do, practically? Well, object to hearsay from GALs, demand evaluator compliance with rules governing expert witness testimony, and probe evaluator methodology for competence and impartiality. Ask the court for an in-camera interview of the children when a child can testify competently. If you need to appeal, you'll need specifics. Get them. Big picture, some GALs and evaluators do solid work. Most, in my experience, do not. Know the proper scope of their roles, insist on rules compliance, insist on competence and impartiality, and don't let the "for the children" rhetoric bulldoze the evidence rules that protect your child's own voice and due process for both parent and child alike.